Yes, Ms. Farber.
My Lords, thank you. Before the adjournment, Your Lordship asked me a question of principle that arose from my opening remarks about whether or not it's the respondent's position that a payment of training costs type of contract can never amount to a restraint of trade. And I gave you an answer to that, some sort of an answer to that, and I'd like now to take Your Lordships to the back of the authorities bundle, the last tab 50, which is the Selwyn Block textbook, Employment Covenants and Confidential Information. And just briefly take you to a line which answers that question more elegantly than I think I did before lunch. So it is page 1318, right at the back of the authorities bundle. It's the first paragraph, paragraph 11.263. And halfway down the paragraph, the writers say, by extension, it's about 6 lines down, by extension it is to be expected that restraint of trade considerations would ordinarily not apply where such restrictions during employment are sought to be enforced by indirect means, such as loyalty payments for continued employment. Now,
read the next line as well.
Yes.
Yes, that said, there may still absolutely. That said, there may still be some exceptional situations in which the paragraph on restraint of trade applies to onerous restrictions on the currency of the employment relationship or restrictions on termination. It's the same point that ordinarily no, but there will be some cases where yes, and that I think is borne out. So in principle, it's possible. It's a matter of looking at the case and deciding whether or not, for a trial judge, deciding whether or not it's a restraint of trade. And the section I have read with the assistance of my learned friend there is a good description of the body of case law, which is in fact in the bundle of authorities, the 30 cases which precede the Selwyn Block extract right at the back. There are 30, I think 29 or 30 cases which all of the 5 eminent counsel that you see before you have sought out to put into this file for the purposes of this appeal. Of those 30 cases about restraint of trade, almost all, the vast majority, 24 out of 30, are about traditional, non-compete, non-poaching, non-solicitation type clauses, where the restraining of the employee from working for a competitor or taking clients to a competitor or taking employees to a competitor is the explicit subject of the clause. That's what it does. And those cases include both a direct prohibition, you must not go and work for a competitor, you must not poach clients, you must not poach or solicit employees, and it also includes some disincentive cases. If you go and work for a competitor, you will forfeit your commission. Or if you go and work for a competitor, you will forfeit your bonus. So both of those types of clauses, explicit prohibition and disincentive, in the majority of cases, attach to explicit non-compete obligations. There are only 6 cases, which are all in the bundle before you, which say simply, in which the clause under appeal says simply, you will be rewarded for not leaving this job. Or you will lose money, you will forfeit money if you leave this job. Whatever you go and do after you leave, just leaving this particular job is the thing that we don't want you to do. And that, in my submission, is what the extract from the textbook is saying, that loyalty for continued employment is the type of clause which is not ordinarily a restraint of trade. And those cases which I'm going to take you to now are cases which, in broad terms, say that generally speak, that on those facts, when all that the clause is doing is saying you will forfeit money if you go and if you leave this job, or we will give you a reward, we will give you money if you stay in this job, those sorts of clauses in the decided cases have not been in restraint of trade.
Sorry, can I just write down what you said? You will forfeit money if you leave this job. And you will receive a reward if you stay.
Yes. A sort of incentive to stay or disincentive to leave.
Well, you will receive a reward if you stay. It's a very different kettle of fish from
it is.
You will forfeit money if you leave.
Yes, I'm characterising it, or I'm grouping those cases together because they are grouped together in that way in the textbook. I'm doing that just for a moment, just to give a sense of what loyalty payments, such as loyalty payments for continued employment, is referring to, because the extracts go on. For example, I won't spend too long on it, but 1319, the next page of the extract, talks about Hubble and talks about, at 11.267, about payment or forfeiture conditional on continued employment, not being wholly settled, but makes the point about the fact that Hubble simply declined to grant summary judgment on the point. So this section, which is headed payment / forfeiture linked to continued employment, is dealing with the two situations, either payment linked to continued employment or forfeiture of payment linked to continued employment, and saying in broad terms in relation to both of those matters in the 6 odd paragraphs that the textbook devotes to this type of clause, that generally speaking, either there isn't any settled law on it at all, or they've ordinarily been found not to be in restraint of trade. It's a summary of the law as it is, and it comes back to no more than the 6 cases which are relevant, or perhaps relevant to this question, or more, let's put it a different way, more relevant to this question than any of the other 24 cases in the bundle, which deal with explicit non-compete, non-poaching, non-solicitation clauses and decisions of courts about those clauses. So what I'm going to do is to take you to each of those 6 cases and say something about each case. I'm going to do it chronologically, starting with Hubble, and that's the case which you've already been taken to behind tab 26 in the authorities file. Page 717. I don't know if
Would you like to tell us what the 6 are going to be, or are they listed in your skeleton anyway?
I will tell you what they are. Yeah. That will be useful, and I will do that. They are Hubble, then the 2 Marshall cases, yes. High Court and Court of Appeal, which are at 29 and 30 tabs. Then Peninsula and Sweeney, tab 34. Tullett-Prebon, that is the case about loyalty payments, which Your Lordship has highlighted as rather different, but I will nevertheless touch on it. That Tullett-Prebon is at 36. The 5th case is 2020 London at tab 38. And finally, the last case in the authorities bundle, Steele and Spencer Road at tab 48.
Yes, Mrs. Justice Bacon.
Thank you. So,
right.
Back to Hubble. I'm going to roll up my sleeves and go through these. I will not spend a lot of time on them, but I'm going to spend some time on them because this court is being asked by the parties and certainly by the respondent to make a decision about how these sorts of clauses should be approached. And the best way to present the current state of the law on that question is to show you the 6 cases where
Yes.
something similar at least is considered. Hubble itself, Hubble's the first, tab 26, page 717. Case from 1987. It was a second appeal to this court. It was unreported, remains unreported, which is why it looks as it does in the
Yes.
authorities bundle. But as you already know from reading it several times in the paperwork and hearing it from my own friend, this was only an appeal against a summary judgment. And in very broad terms, that's because it was a promissory note. So there was judgment on a promissory note. The promissory note was for training costs. And so in that sense, this is the case on the closest facts to the case before you in this appeal. But of course, what we're dealing with just now is principles, rather than applying principles to facts of particular cases. So, second appeal, subject of the first appeal and of the second appeal was only whether a summary judgment decision which had already been made in favour of electronic data systems should be overturned so that a hearing on the facts could take place. There'd been no trial, no facts, no findings of facts, no submissions on the principles, only submissions on whether or not summary judgment should have been entered. In my submission, the views of Lord Justice Mustill, as he was at this time, if they say anything at all about the principles of restraint of trade in these types of situations, if his views tell us anything at all in my submission, they tell us that his view tended to support the respondent in this appeal, not the appellant. And to make that point, I ask you to go first to page 5 of the case report, page 721 in the file. Now, you will have read already, probably several times, the reference to the end of that paragraph. I don't regard his case as so hopeless he shouldn't even be allowed to try, which of course is a very low bar indeed for any sort of principle.
And after some initial hesitation too.
That's, you have my point, my lord, thank you. Perhaps if I just develop it for the benefit of the live stream, the paragraph says this. There's first a list of 6 arguments in favour of the training contract being in restraint of trade, the promissory notes being in restraint of trade. And Lord Justice Mustill says, naturally, Mr. Tabachnik developed answers in response to these points, which it would have been appropriate to discuss if I had found them so irresistible as to justify the conclusion that there was really nothing left for the appellant to argue at trial. In other words, if I was going to uphold summary judgment on this. And then he says, after some initial hesitation, however, I found I cannot go so far. In other words, Lord Justice Mustill almost was persuaded to allow summary judgment to stand on these promissory notes. And then he went on to make the statement which is cited later in later cases and in the skeletons in this appeal about not regarding the case as so hopeless that he shouldn't even be allowed to try. There are just a couple of references in other cases to Hubble. I'm not going to, for the moment, ask you to go to those pages, but I'm just going to give you the page references. Mr. Justice Jack in Tullett-Prebon at paragraph 265, page 1048 of your authorities bundle, says, I do not consider that any principle can be derived from the Hubble decision. And Mrs. Justice Bacon in Steele and Spencer Road, the most recent case about this type of clause, she says in paragraph 47 of Steele and Spencer Road, page 1131, like Jack, like Mr. Justice Jack in Tullet Prebon, I find it difficult to derive any relevant principle from the decision in Hubble. She says something else, though, which I want to highlight. She says, not only was that a case on very different facts concerning training costs rather than repayment of a commission or bonus, but more importantly, so she highlights the importance of the next point she makes, it is clear from the judgment of Lord Justice Mustill, that counsel for EDS had effectively conceded the first stage question of whether the doctrine of restraint of trade was engaged by the disputed contractual provisions and promissory note. The issue in the case was whether there was a restraint, the issue in this case, Steele and Spencer Road, whether there was a restraint of trade at all, i.e. the first stage question, therefore simply did not arise for determination as a dispute in Hubble. I highlight that as another reason, if one were needed, why Hubble is of no value as an authority for any principle at all. In a sense, of course, it's a shame that we don't have the subsequent case, because that would give us an outcome on what are, at least superficially, more similar facts than any other cases we have.
As people in interesting cases do.
Absolutely. Yes, indeed. So the next case is Marshall.
Yes.
You have that at tab 29 for the first instance decision and tab 30 for the decision in this court. Again, I want to take you not to things that you already know about in this case, but to a couple of things that you may not necessarily have thought about yet in relation to the two Marshall cases. The first instance case behind tab 29, the Jonathan Assumption decision in the High Court. That was a trial, so there was a fully reasoned judgment following trial in the High Court. It was a commission case. The clause was a commission clause in an agency agreement. And the single clause about the commission contained first a clause requiring there to be 5 years service before there was any entitlement to commission at all. So you need to work for us for 5 years, it's an agency agreement. You need to be an agent with us for 5 years before you're entitled to commission. And in addition to that, there was an additional condition of a 1 year non-compete after leaving. And Marshall found that the court in Marshall at first instance found that the 1 year non-compete was in restraint of trade. Obviously, it was a traditional non-compete, and then held it wasn't reasonable. So the 1 year non-compete was unlawful.
Well, it wasn't a traditional non-compete.
Well, what I mean by that is that the restriction being imposed by the second condition, you must not compete, or if you compete with us within 1 year, you don't get to receive your commission.
That's different.
It is different, but what it is prohibiting or disincentivizing is a traditional type of prohibition. It's talking about competing for working for a competitor. In that sense, it's about exactly the same thing as all these other cases. It's about companies trying to stop agents or employees working for competitors. Doing that in a particular way by saying you don't get your commission if you work for a competitor within a year of leaving our agency contract. But more importantly, it was held at first instance that otherwise, except for the 1 year non-compete, the clause was lawful. And if I can ask you to go to page 944, which is the last paragraph of judgment. At letter B, the reality is that clause 10G simply introduces new conditions operative from the termination of the agency to the agent's right to be paid renewal commission by reason of the business which he has introduced. If the conditions are lawful, like the condition of 5 year service, they will be applied. If, like proviso 1 and 2, that's the non-compete. They are contrary to public policy, they will not. So there's a statement in that first instance judgment that the requirement, the condition of 5 years service is lawful. And Lord Sumption, Jonathan Sumption in the High Court in 1995 explicitly states that. Now the criticism made of Marshall at first instance is that this was an obiter dictum. This was not what the argument was about. And therefore, whatever the eminence, preeminence of the judge making the comment, it simply wasn't something that was argued before him. And while, of course, that's true, there is actually a rather important answer to that criticism of the importance or lack of importance of Marshall at first instance. And that's Marshall on appeal, which is in the next tab, tab 30. The lead judgment was given by Lord Justice Millett. And if I can ask you to turn to page 952. And I'm going in a moment to take you to what Lord Justice Millett says between letters B and D at the top of that page. But before I do, I'll give you the context, which is that one of the issues for decision on appeal in the Marshall case was whether, because at first instance the non-compete clause had been struck down as unlawful, so that was clause 10G Roman 1, because the non-compete had been struck down as unlawful, there therefore remained no contractual consideration at all for the company's obligation to pay renewal commission. So the company argued, okay, we lost on non-compete at first instance, but that means that there's no quid pro quo for the payment requirement to pay commission because the non-compete's ineffective. Therefore, we actually have no obligation to pay the commission anyway, on an alternative basis, which is that there's the consideration, which was the non-compete, has been struck down. Now, that may well seem like a bad point, and it was a bad point. Lord Justice Millett didn't like it, but the important, and I'll read you the relevant section in a moment, but the important thing is, on appeal, it was directly an issue whether the remaining parts of clause 10G were amounted to consideration, were lawful. So it was a part of the outcome of the appeal. It was a part of the ratio of the decision. And and I'll now read the relevant section. It begins, just find it. It's the top of the paragraph, actually, between A and B. The defendant places great reliance on the fact that clause 10G provides the sole basis for the plaintiff's rights to renewal commission after termination of the agency agreement. Accordingly, it insists clause 10G alone constitutes the relevant contract for present purposes. On this footing, it is submitted either there is no consideration for the renewal commission, or the invalid restraint provides the only consideration for it. I've already given my reasons for rejecting this argument. Even if clause 10G is considered on its own, the consideration for the renewal commission consists in the performance by the plaintiff of the two conditions on which it is made payable, one of which, the restraint, is invalid. The other, at least 5 years' service, is not. Accordingly, if clause 10G were considered on its own, I would hold it valid, since I would regard renewal commission as payable partly in consideration for the 5 year service and not exclusively for the invalid restraint. Now, he then goes on to say that there are actually other elements of consideration in the contract apart from this clause. But he was asked on appeal to deal with the question of whether this clause was lawful, and he decided that it was.
Well,
so you have
the clause stripped of the objectionable restraint which Mr. Sumption had struck down was that it's the renewal commission shall be payable if at the date of termination of the agreement agent has been an agent for not less than 5 years continuously.
That's the part he didn't strike.
Yeah, correct.
Yes, it said that, and then it said, and also, so long as he doesn't compete for a year after leaving. Yeah. That's the part that was struck down.
Yeah.
Yes. Yes. So on appeal from that there were various points of appeal in the Marshall case. One of them was that having struck down the non-compete, nothing remained of Clause 10G, and therefore there was no consideration for commission, and NM Financial Management still didn't have to pay the commission, even though they'd lost at first instance on the non-compete lawfulness issue. And the answer from Lord Justice Millett was, no, there is a lawful condition, which is 5 years service. And to the extent, and there is criticism in the subsequent cases and in submissions about the fact that in Marshall, the point about the 5-year service as a condition for receiving commission was not the ratio of the case. I'm highlighting that certainly was true at first instance, and it was a comment made for completeness by Lord Sumption sitting in the first instance in the High Court, but that by the time the case got to appeal in this court, the question of the lawfulness of the remaining part of Clause 10G was squarely before the Court of Appeal, and the Court of Appeal answered the question. And therefore, you have, to the extent that we have any cases at all dealing with these types of clauses, here is a case decided in the Court of Appeal which says that a clause requiring an individual to work for 5 years before they can earn any commission on an agency agreement is a lawful clause.
So what? I mean, what's the relevance of that part of the case to the present case?
These cases are, none of them, authority for the principles that you have to decide, and that's why this case is important. But they are cases where facts which bear some similarity to the present case have been considered by other judges sitting in other cases, and decisions have been made as to whether such clauses are lawful or not, sometimes with reasoning, sometimes without. It is a jigsaw puzzle of incomplete case law, which it is important for this court to bear in mind. And all I'm highlighting, and it is worth highlighting, it seems to me, is that Marshall is often criticised as being of no value at all because this was not a point that was at issue in the case. It's just a throwaway statement about lawfulness. And I'm making the point that that's not right, that on appeal it was argued that that the clause was unlawful as a whole, and the decision of Lord Justice Millett was that was not right, and that the clause still had effect and was lawful. That's all. If it's not a point that Your Lordship considers particularly helpful, I'll move on from it. I certainly don't want to spend any more time on it.
Well, if I may say, the Sumption decision is plainly relevant.
Yes.
And was proved on appeal. I'm not sure it was even an issue.
Yes.
The issue on appeal was whether 10G1 could simply be severed, whether
that was one of the, yes.
the contract that was left was enforceable. But a contract saying that you can only get this type of commission on completing 5 years service may seem a bit odd, but I don't see why it's in restraint of trade. You might this isn't an employment case, in fact.
No, it's an agency.
But even if it were, you could have an employment contract under which, on completing 5 years of service, you got some enormous bonus, or as it were, a gold watch, but it really is
golden handcuffs. It's referred to.
Yes, and some enormous financial reward. But if you leave after 4 or 4.5 years, you don't get it. Well, tough, but I don't see why restraint of trade is applicable to that sort of case.
Well, I don't disagree with that at all, and so I don't. I mean, I'll let me come as I go through the cases to what points are more and less relevant to the facts of the case.
The next
and I appreciate that I'm taking you in some through these cases in a more structured and more detailed way than perhaps you've heard so far today on any of the cases. But it is because you don't have, as a court, a case on point to apply that it is important to do this. The next case is the Peninsula and Sweeney case. That is at tab 34. And that is a case of the Employment Appeal Tribunal, obviously a specialist tribunal which deals every day with employer-employee contracts. It was a case which had a full trial before a tribunal, received a reasoned decision, and then was followed by a fully argued appeal. The judge was a High Court judge, Mr. Justice Reimer, sitting with lay members, and it was very shortly about earned commission being forfeited if an employee left their employment before the payment was due of that commission. So this was a case, again, not on the same facts, none of these cases are on the same facts, but it was all about, this case, a disincentive to the employee against leaving. In our case, it's about paying a debt. In the Sweeney case, it's about not receiving a commission which you have earned as an employee. You work for that commission, you earn it, but then you leave and you forfeit it, you don't receive it. And at page 991 in the bundle, I think the pages got a bit lost amongst the text, so it's easier to give you the paragraph numbers. It's paragraphs 38 to 44. All of them are on the same page. And
I've forgotten the facts of this. You had to be still in service at the end of the month, was it?
Let me just check. I think it was longer than that. Let me just check that.
It says at the end of the month between the hole punches in the headnote on 985.
Yes.
I can't see it, but I'm sure I'll take your word for it, my lord. I'm sure that's right. Oops.
Para 10.
Sorry to take a bit of time. Just make sure that I'm not missing something that I should deal with. Yeah, it's the end of the following month after the customer had paid the fee. So it's slightly, it could potentially be up to...
Very bad timing by Mr. Sweeney. All right.
All right, but again, of course, these are not the same facts, but there are some similarities and some useful points to be gleaned from the way in which Mr. Justice Reimer tackled this question of whether such a clause could amount to a restraint of trade. And it's paragraph 42 on page 991 that is important. It's a straightforward, rational, and easy to understand paragraph, and I commend it for that because I think that these principles should be capable of being stated in a straightforward and rational way. what paragraph 42 says is this: the tribunal's point is that because Section B had the effect of imposing what they regarded as a penalty on resigning employees, it must have operated as a disincentive on them to resign and therefore go and work for competitors whom they might, but for Section B, have wished to work for. We regard the tribunal's conclusion that those circumstances turn Section B into a contract in restraint of trade as wrong. We do not consider it seriously arguable that the commissional penalty that Mr. Sweeney suffered on resignation arose under a contractual term involving an unlawful restraint of trade. His employment contract did not impose any restraint on him as to whom he might work for or what he might do after leaving Peninsula. So that's, I say, an important paragraph because it is a good example of how a straightforward and clear line of reasoning should be applied in cases where the facts are that the clause does not, on its terms, stop the employee from working anywhere else, doesn't put any restraint on what he might do when he leaves the company.
I thought you accepted that that is not an absolute rule.
No, that's right. I mean, but bear in mind, my lord, that what Mr. Justice Rhyme says is, we do not consider it seriously arguable that the commission penalty that Mr. Sweeney suffered on resignation. You know, there are always, it is possible, again, back to that quantum definition, that there are always going to be the possibility of clauses which are which are a forfeiture of commission, but they are so onerous to an employee that in practical terms they operate to hamper that person's freedom to compete or to trade. That, in principle, that is possible, and again, that is what the textbook at the back of the bundle says, that ordinarily these sorts of clauses are not going to be in restraint of trade. The respondent's notice in this appeal is not attempting to set any rigid limit on the restraint of trade doctrine. May I say, unlike some of the submissions made this morning by Malone French, I'll come back to in relation to legitimate interest. Quantum actuarial is very clear and is the authority that it is a flexible, non-rigid doctrine which has to be applied to the facts of the case. What all that this respondent seeks to do, by way of the respondent's notice really, is to persuade this court that this training investment contract was not in restraint of trade, and therefore that the order of the appeal judge dismissing the appeal below should be upheld. And that's a different reason than the reasons which she gave for upholding the appeal judgment, which were the legitimate interest and reasonableness.
All right. Anything else from Peninsula?
Nothing else from Peninsula.
Right.
Tullet Prebon, I will just mention, you have the point already, it's at tab 36, that Tullet Prebon is about a very, very highly paid employees receiving hundreds of thousands of pounds in loyalty bonuses or retention payments, and then choosing to leave anyway and forfeiting those payments. The simple thing to say, the only thing to say about Tullet Prebon is that it refers to Sweeney and makes the same point as Sweeney, that whatever the disincentive effect, in this particular case, it didn't affect the employee's ability, the very highly paid employee's ability to seek other work after leaving. So that's Tullet Prebon from 2010. Then Riley, which is at tab 38. That is High Court first instance hearing before David Donaldson QC in 2012. It is not only a first instance decision, but also a summary judgment hearing, not a trial. And it's important to highlight, because this is a case relied on heavily by the appellant in this, below, in relation to restraint of trade, that although this was a case, and I'll come on to this, which referred to Hubble and applied Hubble, this was not an employer-employee case, or not simply an employer-employee case. Riley was a case in which Mr. Riley had sold his business, had received a payment of 1.5 million for that sale, and was being sued for the return of that 1.5 million. That's the context in which this judgment is given. And at page 1079, there are lots of other arguments in the case which were all dismissed on a summary judgment basis. All sorts of arguments by Mr. Riley to avoid having to pay back the 1.5 million. But the one argument which was allowed to proceed to trial was the one at 1079, restraint of trade, beginning with a discussion which began at paragraph 39 of the case report. So that's where the relevant section of the Riley decision is. But, as with Hubble, in this case there was no trial, there had been no evidence, there had been no submissions on the law other than a defence, a summary judgment application, and then submissions on the summary judgment application before the judge and a decision. So, on that basis, the views being expressed by the Deputy High Court Judge in Riley were only views about whether there was a real prospect of success on summary judgment, that's all. And at paragraph 47, on page 1082, you have the judge's answer. I conclude there is no authority binding upon me which decides that a repayment provision can never, through disincentive or golden handcuff effect, amount to a restraint of trade requiring objective justification. Indeed, EDF, which is Hubble, sorry, I'm just Rover's Court, forgive me. EDF is it's actually EDS, not EDF, but it's the same case. It's Hubble that he's referring to. Indeed, Hubble appears to suggest the contrary. Plainly, however, the point calls for resolution by higher authority than I can provide.
And here we are.
And here we are with an opportunity to deal with that. I will just make one point about David Donaldson QC and something which he says that is, I say, helpful and right. And he says it in paragraph 46, so that's one page back. I might have just the wrong. Just give me a second. Yes, sorry, it's paragraph 44. Don't know why I got that wrong. 1080. Paragraph 44. The judge deals with Hubble in some detail, and at the bottom of the page he says this: it was therefore the view of two eminent appeal judges in Hubble, albeit not contested by either counsel, that an analogous repayment provision was capable of being a restraint of trade. And I just highlight that because there's been some significant criticism of the last case, which I'll take you to, Steele and Spencer Road, on the basis that these are so different, commission and bonus cases, that you can really not read anything across from Steele and Spencer Road that is useful to this court in relation to training costs. But of course, Hubble was a training costs case. My learned friend's been very clear with you about how important it is that the facts of Hubble are similar to the facts of this case. And here you have a judge dealing with a case which is not about training costs. It's about a return of a business sale payment, saying that in principle, training costs provisions are analogous to other types of repayment provisions.
It's also it's often dangerous to take statements made in sale of business cases and carry them over into employment cases.
Yeah. Yes.
ever since Nordenfelt, there's been the two types of case, and people who sell their businesses and get large sums can more easily be restrained than ordinary employees.
And that's presumably why 2020 London went for summary judgment in this case, absolutely. But, you know, this is the game, isn't it, I think, my lord, of picking statements out of cases which are on sort of similar facts and saying, aha, well, this case shows that you must do it this way, you must do it that way. I don't think any of the cases do say anything like that, but the statements made by the judges in these 6 cases give some assistance to how to approach this particular set of facts. Finally then, Steele and Spencer Road, which is at the back of the bundle behind tab 48. That is an appeal decision in the High Court from a judgment which followed a full trial. It was about a bonus clawback on leaving employment, and it was a bonus scheme explicitly stated to be an incentive scheme, incentivizing employees to remain in the company's employment, because if they left within 3 months of receiving a bonus, they had to pay it back. It's
discretionary bonus, and it's paid in January, but you have to stay another 3 months, otherwise you have to pay it back.
Exactly. That's it. That's right. Those are the facts. And paragraph 35. Just find a page reference. I didn't make a note of it. 1309. Mrs. Justice Bacon acknowledges or states it's clear from this case, and that's the Marshall case, just referred to in the previous paragraphs, that the law recognises indirect restraints of trade where the restraint derives from the loss of a benefit rather than a direct prohibition on competing trade.
I'm so sorry, Mr. Furber. Which paragraph 35. Are you?
35, sorry, my lord. 1309, bottom of the page, paragraph 35.
Oh, yes, I see. Thank you.
It is important, so that first, I'll just go to that again. The law recognises indirect restraints of trade where the restraint derives from the loss of a benefit rather than a direct prohibition on competing trade. It is important to note, however, that Marshall does not suggest that any provision which leads to the forfeiture of a benefit, if the employee leaves the relevant employment, is a restraint of trade. Quite the contrary. And then she goes on to deal with how Marshall dealt with that. So again, we come back to...
It's an ambiguous phrase, isn't it? I mean, some people, when they say a provision is a restraint of trade, mean it's an unlawful restraint of trade. And if that's how one should understand paragraph 35, second sentence, then it's obviously correct. The alternative way of using the phrase is it a restraint of trade, i.e. is it within the doctrine at all? Is there any reasonableness test to be applied? If that's what Mrs. Justice Bacon meant, it's rather more controversial.
Well, the best way to understand what she means in paragraph 35 is to go to paragraph 53, which is at 1312. And I did briefly take you to Tullet Prebon just so that this would make sense, because this was not about, this case, Steele and Spencer, it is not about extravagant loyalty bonuses, it's about clawback of earned bonuses. And she says, I do not consider the reasoning in Tullett-Prebon to be wrong. There is no doubt that an employee bonus or commission scheme, which is conditional on the employee remaining in employment for a specified period of time, operates as a disincentive to that employee resigning. That does not turn such a provision into a restraint of trade. As Mr. Justice Reimer said in Sweeney, the disputed employment contract did not impose any restrictions on where Mr. Sweeney might work after he left the defendant. The same was true of the disputed clauses in Tullett-Prebon, and the same is also true of the bonus clawback provisions in the present case. And so, stepping back for a moment and thinking about what principles this respondent asks this court to enunciate in relation to restraint of trade, it is this. Not that it is impossible for provisions which require a payment or forfeit a payment or provide a golden handcuffs type clause cannot ever be in restraint of trade without a concomitant non-compete condition attached to them. It is possible, but in none of the cases which have been decided has such a clause ever been held to amount to a clause in restraint of trade. There have been Hubble and Riley which say the matter should go to trial. That question needs to be resolved.
I'm not sure that's a principle. You say it's not impossible. So what is the test as to when it is not only possible, but the fact?
In the end, the test is in quantum actuarial, which is it's a fact-sensitive question for a trial judge to decide on the facts of any case. But in my submission, there is a general point of principle to be taken from the run of these 6 cases, which is that it is very difficult to establish the existence of a restraint against an employee competing with their former employer when the clause that is being impugned as a restraint of trade doesn't ask them not to work for another employer, doesn't ask them not to poach clients, doesn't ask them not to poach employees. It just says to them, please stay with us for however long, 30 months in this case, 5 years in the Marshall case, 3 months in the Steele and Spencer Road case. When all that the clause is doing is saying, we want you to stay with us for longer, and we'll either offer you an incentive to do that, or we will disincentivize you from doing that by making you pay something back after you leave. Those sorts of clauses, which don't do anything other than say, please stay with us for longer, are, generally speaking, not going to fall within the doctrine because they are not restraining the person from the freedom to trade. Those words in quantum actuarial, paragraph 60, subparagraph 6. On the facts, there could be some circumstances where, as a matter of fact, such a clause does restrain the person from a freedom to trade. But it's going to be difficult to establish those sorts of facts. So, I'm going to deal now with this, rather than the case law, which I have now taken the court to. I'm going to say something about training costs cases versus commission and bonus cases. And then I'm going to say something about this particular case, because, as I've said, the respondent's notice asks you to uphold the judge's the appeal judge's dismissal of the appeal below on additional grounds, and that those additional grounds are that this particular training investment contract is outside the doctrine of restraint of trade because it does not restrain this individual, this appellant, from his freedom to trade. So, to begin my point about how this court should treat, how courts generally should view training costs provisions rather than by comparison with commission and bonus payments. I will make some points about the payment provisions in this contract. I don't ask you to go to the page for now, but I will give you the page reference. It's in the supplementary bundle at page 28. That's the relevant part of the contract for training investment.
Sorry, supplementary bundle.
Supplementary bundle, page 28, begins at 26, the training investment contract. And I'll be taking you to some of the clauses. And to summarise my submission briefly before I give you my points about it, paying back or paying a training costs as a debt after leaving employment is nowhere near as harsh on an employee as having to pay back a bonus or a commission which that employee has already earned. So to the extent that there's a comparison made in submissions before you, and certainly in written submissions, about bonus and clawback being different because they are much less harsh than the training cost debt being repayable, I say it's in fact the opposite of that. Why? Because this training debt, firstly, is a crystallised figure, an amount set in the contract, known by the employee from the start. You certainly can't say that about bonuses and commissions. The employee doesn't know at the point, obviously, when they begin to work, what bonus or commission precisely they might earn. Now, what does that in practical terms look like? If you have a clause which forfeits commission or bonus if you leave within a certain amount, within a certain number of years or a certain number of months after earning the commission, in practical terms, the longer you work for that company, the more successful you are, the better the commission you earn, the better the bonus you earn, the greater the penalty, the greater the forfeiture of money if you leave. It's a ratchet that if you are successful in the job only gets more and more disincentivizing to leave. This contract, this training contract, is the precise opposite of that. Very set, taper down of debt. The way it works, it is at page 28, but I'll give you the bones of it, which I think you probably already have from my learned friend submissions anyway, is that you work for 12 months. Then every month after the first 12 months that you work, the cost of the training debt tapers down by 1/18, because after the first 12 months, you are, as an employee, doing productive work for the company. There is a repayment of the investment in your training from month 13 to month 30, to the end of the 18-month period.
Sorry, what point does this go to? Reasonableness?
It is. It goes to both. It is relevant to reasonableness, though I will not be addressing you directly on reasonableness. But it also goes to whether or not there is any disincentive effect at all in these provisions. On the facts of the provisions, whether this is in fact a restraint of trade. So is it a restraint of trade? Is it a restraint on the freedom of this individual to trade to require them to pay back a training debt in a decreasing disincentive, because each month after their first 12 months, they are paying back 1/18 less than they were before. Unlike the clawback and bonus cases, it's not a case of a cliff edge where you must work for a certain amount of time. If you don't work for that amount of time, you lose everything. You lose your entire bonus and your entire commission. There is instead a mechanism by which the actual debt that you have agreed to at the beginning of the contract, the one, in this case, £8,108, gets less and less the longer you stay, because you are providing productive work to the employer. And that means that the longer you stay, the easier it is to leave, until you get to, say, the 16th month of the taper, so 12 months plus 16 months, at which point all you've got left to pay back is 2 payments of 1/18 of your training debt. So there comes a point, doesn't there? There must come a point where there's no disincentive at all, where you've got so little to pay back that you can't say that the repayment requirement is any longer a disincentive.
But at any time from the 6-month point to the 12-month point, £8,108 is payable.
Yes, that's right. By monthly payments, not as a lump sum.
Yeah, well,
but yes, that's right.
Yeah.
Yes, but one can't. It would be wrong to view the effect of the clause as just the requirement to pay back the £8,108 over 18 months at 12 months. That is part of it. But another part of it is if you stay for 13 months, it'll be £8,108 minus £450. And if you stay for 14 months, it's £450 less, and so on.
But what does this have to do with whether it's a restraint of trade as opposed to reasonableness?
The question of whether the clause as a whole is hampering the individual's freedom of behaviour, freedom to go off and work for somebody else, can only be answered by looking at the overall effect of the training investment contract, not by isolating one particular element of the payment. Yes, that is part of it. It is relevant. I'm not saying it is not relevant. But I am saying that when one takes a step back and looks at the entirety of the package which the appellant signed up to when entering into this training investment contract, he wasn't just signing up to, if you leave at 12 months, you have to pay back £8,108 over 18 months. He was also signing up to, and there are other ways in which you could behave where that payment would be lessened. And that's a part of the relevant package. Why is that important? Because it's not even in my submission right to view the payment provisions in isolation. So I've said it's not right to treat the payment at 12 months in isolation. It's also not right to treat the payment across 30 months in isolation. The way that this package is structured from its inception, the purpose of the training investment contract for the appellant, for the person against whom it is said there is a restraint. The purpose of this training investment contract is as a gateway, a package through which this appellant can finally become able to work for companies in the IT sector. The package as a whole enables him to trade in an area, in a sector which he wants to trade in but currently can't. This is pre the start of the contract. There are some important findings of fact about that which are not appealed and which are important, that relate to whether in substance this contract restrained the behaviour of this individual at all. And I'm going to take you to those now.
Well,
First,
you have to look at it, don't you, at the time of signing.
Yes,
you
that's
can't,
right.
You can't say, well, in fact, he went and got a better job.
I don't say that. Absolutely.
Yeah.
None of the findings I'm going to take you to are anything to do with that. Page 100 of the core bundle.
Are we finished with the contract now?
Thank you. Yes. I'm not promising we won't come back to it.
No.
But I think,
All right,
I think
but for the moment,
for the moment.
bundle control.
Did you say page 100?
Page 100 of the core bundle, judgment, paragraph 14. These are all findings that relate to matters known to the appellant before he signed the contract. Paragraph 14. The defendant had an education at a good school and then he attended university where he did music, which is not immediately suited to the IT industry. Documents in the bundle show he was considerably indebted through this education and was living in his overdraft. He applied for in excess of 50 positions in the IT industry before applying for the role as a trainee software QA engineer with the defendant in 2019. That's the first finding of fact, which is a fact. It is not appeal. Then page 116. Paragraph 47. And it's about 7 lines down. It's a long paragraph, 47. It's about 7 lines down. There is the following express finding of fact. I find, having spent a very considerable amount of time trying to get into the IT industry, the defendant would have known the likely position was whether or not he was subject to a trainee debt. He would have known he had to do his time as a trainee QA, and that once he qualified, he was going to be able to make a considerable amount more money than having not been a trainee, because he would have had that experience. Very important finding. That
Can you read the first bit of the sentence as well, please?
I'm sure my learned friend,
I mean,
I'm sure my learned friend will have things he wants to say about my submissions, but he can say them in reply.
yes, but look, I mean, of course, this was an extremely desirable job from which he might well benefit, as is often the case with people on their first job. Very difficult to get into the market. Very desirable job, increases his earning potential and so on.
Well, it is that, but
you're
it's more
saying
than
that the restraint of trade doctrine therefore doesn't apply.
On the facts as found, this individual was not restrained by this clause. I'll give you the other findings in a moment, but let me answer that point. Because he wanted to get into a sector which he had not been able to get into. He knew that once he got his training, he would be able to get a much better paid job with the benefit of that training. And he had no way of getting that training because of his debts, except by earning money and doing it by way of a job. No, the only way in which he was able to do that, the only company which was willing to take him on without any experience or qualifications in IT, was a company which wanted its investment in time and money in training employees to be protected by being able to recover its investment if he left early. Now those are arguments about legitimate interest and reasonableness, I understand that, but stepping back even from those points, in my submission, the correct result of the findings of fact that you have in the judgment about the circumstances of this individual are that this clause did not operate in any sense at all to restrain his freedom to work. And in fact, it was the opposite. And I'm taking my points out of turn slightly, but I'm conscious that I need to get this point home to your lordships. This was a situation in which, without this this contract being in place, he would not have been working. He would not have been able to go and work for any business in this sector. Those are the findings, that he was not able to work in the sector in which he wanted to work. He was not able to trade. He did not have the freedom to trade because he was stuck without money, without training, and without experience in the sector that he wanted to get into. And
You've emphasised that he did a music degree and this was his 50th application, but is the question whether the restraint of trade principle applies really as specific as that? Is it different if he did a more vocational degree or if this was his first or his second application?
Quantum says that these cases are very fact sensitive.
So
the question is whether the individual is restrained from trading. Another individual who entered into this particular contract, who had different personal circumstances that have to be a different trial about, but this individual was in a situation where he was offered a package which included, if you don't stay beyond 12 months, then you need to pay back these crystallized costs that we are investing in your training, and in relation to which we would like to have a productive member of staff for at least 18 months after the end of your training. If you want to get into this sector, this is one way for you to do that. Take it or leave it, and he took it.
Well, in the old days, before national minimum wage was introduced, on these facts, an employer would say, you can come and work for us for nothing. You'll think yourself lucky to have the opportunity. Unpaid internships, or you're only paid travel expenses, lunch and vouchers and so on. That was what was done, and it was lawful then. And people took the jobs because it was the only way to get into the industry. Well, that's not lawful anymore, so the solution of the draftsman of this contract is, if you come to this highly desirable training job, you'll have to repay us a very substantial proportion of your salary for the first 6 months. But don't worry, it's the way you get into this industry. You're saying the restraint of trade doctrine doesn't apply for that reason?
Yes, on the facts that there is the individual has to decide whether they want to get into a particular sector of work. The company is entitled to say to that individual, not that we're not going to pay you, because he is receiving payment. Not only is he receiving a salary, he's receiving a set increase in salary, which I think you've already seen in the contract, from 18 to 20 to 22, promised increase in salary, yes, the longer he stays. There is a package there which is to his benefit. And there isn't a requirement as part of the trainee investment contract to repay that money immediately upon leaving. There are all sorts of elements in that contract about the way in which that money, that investment is to be repaid. It's only in restraint of trade, following the quantum actuarial paragraph 60 principles, if it in fact restricts that individual's freedom to trade. And on the facts as found by the judge, it simply doesn't. I am not making a general point about about market forces or about different sectors. Different sectors are entirely different. And my learned friend referred to trainee solicitors earlier and made a sort of grand gesture about the way that the market operates more generally. Well, of course, that's an entirely inappropriate comparison to make in circumstances where, because the professions have an extremely complex and set of regulations about how training is to be done, what the contents of the training are, the fact that one has to have conducted, the fact that one has to have had a law degree before starting that training. There are many, 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 many obligations which a trainee solicitor has to comply with before they begin their training contract. And as a result, there have been 50 years of regulatory rules that have developed in order to ensure that in the professions there is a flow of individuals coming in who are being paid during their traineeship. This is a good example of how the facts of one sector, the facts of one case, are not the right way to think about the facts of another case. This is a sector in which there are no regulations about what you have to do. There is no requirement to have a degree of any particular kind. There is always the possibility for somebody like the appellant in this case to take on an additional debt, take a vocational college course in IT, and then get a job in the IT sector as someone with qualifications. An alternative, if he does that, then he has to pay that. That's a service that's provided to him, an education service. He has to pay for it. For an individual who doesn't either want to or have the money to pay to be trained in an area where, in practical terms, no one wants to take him on unless he has the training, it's perfectly reasonable for that employee to view an alternative to a vocational training contract, to a vocational training college, to be going to work for a company, earning a salary, so not paying upfront at all for any of that training, and in fact not paying for the training at all so long as they stay for a certain amount of time and do productive work for that company. In the meantime, unlike a vocational training college, they are earning a salary. They are getting experience. Their CV is improving because they are now a person who is not coming into the IT sector with no experience at all, but someone who has had a job in IT. And a part of that package is that in order for that company to be able to offer that package, they also have to be able to recover their investment should that person leave before they've done any productive work for the company. That is not, in principle, in my submission and on the facts, a restraint of trade for this individual.
Right. Well, that's the respondent's notice point.
It is. I'm very conscious of the time, and I want to make sure that my learned junior has time to address you on reasonableness. I'm just going to give you the page references for the other findings of fact, but I won't take you to them if that's all right.
No, I'm sorry, I don't deal in page references. If you want to rely on findings of fact, you have to show us.
I will then.
What they are.
Page 116.
Yep.
Paragraph 48. Halfway down. As I have said above, the defendant could leave at any time and would only need to secure around £6,000 per annum pay rise to be in the same position financially as he would have been if he stayed at the claimant to pay off the debt.
Is it relevant that as the judge notes here, the claimant can terminate the employment contract at a week's notice? And Mr. Solomon showed us this morning the provisions of the two contracts. The 8,108 is, suppose the employee leaves between month 6 and month 12. Could be for any reason.
Yes.
Could be his choice, it could be the company's choice.
Yeah, that's right.
You say, well, that's just how it is. The restraint of trade doctrine doesn't apply, it's a simple debt.
Yes, I do say that because, and the example that your lordship gave to my own friend was important, and I'll pick it up now. Let's say that this debt wasn't recovered against this individual. So let's say that this was a package without a training investment contract attached to it, so that this individual takes a job for a salary, receives training for 6 months in that role, and then leaves to take care of family members who require care, or decides to leave the labour market completely, decides to claim benefits or try to claim benefits instead of working. That too, that's something that individual would be free to do, of course, in the absence of the training investment contract. It is important to say that with the training investment contract in place, with that package in place, which the individual has been presented with and signed up to, he knows that if he does choose to leave and not work after he has left, whatever his reason for leaving, whether it's because he chooses to go or any other reason, if he goes and he chooses not to work, he's going to have a debt to pay, which is going to be difficult for him to pay. And so on the simplest level, and I don't apologise for this, I think simplicity is important in dealing with these principles on the facts. On the simplest level, having a debt to pay which reflects the investment the company made in training him before he became productive is an incentive to him to ensure that he either remains with that company or gets a better paid job. And of course, that's not an artificial question.
You didn't answer the point I was putting to you, is that the sum is repayable, as I understand it, even if the company dismisses him.
Yes.
But you say the restraint of trade principle is not applicable, it's a simple debt.
He has received a service, a training service from the company. That could have been provided by a vocational training college. As it is, it's provided by his employer and he has received a salary for it. There is a difference between the run-of-the-mill training on the job in a job in which any kind of job not being specific to any particular sector, and between that sort of ordinary day-to-day training and a job in which the technical skills required for that person to be able to do the job at all take a number of months to train that person to do. And that's precisely, by the way, the basis of this contract, one which was presented and accepted by the individual. It's explicitly stated in the contract that that person will become productive and their skills will become marketable after they have done 6 months of training. The second 6 months of the 12, the months 7 to 12, are explicitly stated in the contract to be months where there is still some training, but the employee has become sufficiently productive that there's no longer zero productivity to the business from that person. And that's why the training debt relates only to the investment in the first 6 months. And so there's a real straightforward, clear connection between the complete lack of productivity, the effective operation of a training college by the employer, but with a payment of salary attached to it in the first 6 months, and what happens after that, which is after 6 months, including in months 7 to 12, as well as after month 12, when there is productive work being done and there is no further debt in relation to any of that time after month 6. The debt relates to months 1 to 6, when effectively the employer is operating a vocational training system for the individual without any productivity from that individual.
Did the DDJ make finding the fact that this was of no value to the employer at all, except in the long term, and it was like being sent to a training college, except more expensive because the employee has to pay for a certain number of hours at £60 an hour of supposed mentoring.
Sorry, I was just looking at my note. Would you mind repeating just that last part about?
Yes. Are there findings of fact in the judgment at trial saying this supposed contract of employment, unlike most contracts of employment, was of no value to the employer at all in the first 6 months, that in effect it was a training equivalent to a training college, so all the salary paid must be treated as equivalent to training college fees or a university grant?
That's not a finding of fact. But the terms of the contract explicitly state that the point at which the employee becomes productive is after the 6 months. But let me take you to the final finding of fact that I want you to have in mind. It's paragraph 52 on page 1.
Yes.
And it's the first section. Although this was not particularly explored in evidence, in my judgment, it is highly unlikely, given his previous lack of success, that without the training or equivalent training provided by another employer, the defendant would have been able to secure a qualified position. Therefore, standing back and looking at what both parties would have reasonably contemplated at the time they entered into the contract, it seems to me, firstly, both knew this was a way into the IT industry for the defendant and either trainees. Secondly, it would have been necessary to invest significant time in training those trainees, especially one such as the defendant who had no practical experience and no formal academic experience of IT, at the cost to the business, whether this is an external or internal cost. And that doesn't specify 6 months, my lord, but those are the terms of the contract which the judge has cited in the judgment. The terms of the contract are that the point at which the cost to the business, the investment in the business starts to return, the investment is at month 7. That is why the calculation is of the costs in the first 6 months.
The contract says that, but that doesn't make it true. i.e. that he's not performing any services of any value at all in months 1 to 6.
No, and these are all imperfect statements. Obviously, it's not particularly useful to talk in absolutes, ultimately. The question is only whether the package which was offered to this individual operated in restraint of trade. And if I can, I'm conscious of my timings, and I want to make sure that I pick up the right points and I've highlighted them. But I just want to, perhaps just in moving away from this point, want to highlight what was said by my learned friend in answer to a question from your lordship this morning. My learned friend took you to clause 8.10 in the contract, which was about the expenses, the external expenses being repayable. And you asked my learned friend whether that was in principle recoverable. My learned friend replied it could be a restraint of trade, but it would likely depend on the clause being justifiable and reasonable. And your lordship asked a follow-up question, which was, well, what is the legitimate interest if that clause is enforceable? That's the expenses training clause. And my learned friend said this, and I've checked this with the learned junior sitting behind me to make sure I've got my note right of what my learned friend said. It may well be that it's not a restraint of trade at all on that basis. But if the clause is set up that way, the employee has the option to go on that course, knowing they would have to repay it if they leave within a period of time. That may engage the restraint of trade doctrine or not. If it does, presumably it is related to the stability of the workforce, because the employer is entitled to protect the employment and training and expense of its employees while employed. So I fear I have perhaps run down a bit of a rabbit hole in the last half hour on some of these matters, my lord. But ultimately, all I'm trying to get at is that it is artificial to pick on particular elements of this contract as being, as restraining the person who signs it from working. What must be done and what should have been done at first instance, but in fact the judgment simply just doesn't analyse restraint of trade at all, really, the first instance judgment. What should have been done at first instance is a proper analysis of whether the package offered to this individual in his circumstances when he was considering taking this job was a contract in restraint of trade. Let me just check for a moment through my notes and see if there's anything I've missed before I go on and deal with legitimate interest. No, I'm grateful for just taking a moment there. I've covered everything that I wanted to cover in relation to restraint of trade. No, I don't mind that. Just make sure that we find the time at the
Of course. My lord, I've just asked my learned friend if it's possible to rise for 5 minutes. I apologise to the court. Of course, this will come off my time rather than the respondent's time.
Okay.
I'm very grateful.
Court rising, please. right is able.
Yes, Miss Furber.
My Lord, thank you. I'm going to deal now with the legitimate interest
Yes.
ground of appeal. And I'm going to take you to the case of Dawn A. Day,
Yes.
which is in the bundle at tab 31. Pardon me. It's page 958, paragraph 30. It's a decision of this court, and I say it provides a complete answer to this ground of appeal in a very straightforward manner. Lord Justice Evans, paragraph 30, in my judgment, far from confining the circumstances in which covenants in restraint of trade may be enforced to certain categories of case and defining those categories strictly, the courts have moved in the opposite direction. The established categories are not rigid, they are not exclusive. Rather, the covenant may be enforced when the covenantee has a legitimate interest of whatever kind to protect, and when the covenant is no wider than necessary to protect that interest. So, the principle in paragraph 30, which is very important in Dawn A. Day, is that concomitant with the flexibility of the doctrine, when it applies, when it doesn't apply, this fact-sensitive, non-rigid nature of it, concomitant with all of that is the flexibility of the legitimate interest principle. And that must be right, because if the legitimate interest test is to be applied in the real world rather than just in courts of law, then new species of restraint that are dreamed up by parties must come with new types of legitimate interest. It's not right, as my learned friend didn't quite say in oral submissions, but certainly what said in, or his learned junior said in written submissions, that the respondent can be criticised for drawing on legitimate interests which are not recognised as in previous cases. The three form legitimate interest categories: protection of goodwill, confidential information, customer connections, stable workforce. These set species of legitimate interest are there because they are relevant to the traditional restraint of trade type of clauses. If you have, as the 26 cases out of the 30 in the bundle do, if you have non-competition clauses, non-poaching clauses and non-solicitation clauses, then the companies which are seeking to uphold those clauses are going to rely on things like goodwill, customer connections, and so on. In my submission, to tie, and if this is what the appellant seeks to do, to tie the respondent only to those types of legitimate interest which have previously been recognised in cases, is effectively also to tie the entire restraint of trade doctrine to very rigid types of contract which have as their corollary particular types of legitimate interest. That isn't right. It directly contradicts the way in which the existence of the doctrine is described in quantum actuarial. It is a broad and flexible rule of reason based on the facts. And how does that apply here? Well, you have, for what it's worth, two cases in the bundle where on other facts, in other sorts of contracts, in principle, the investment of time and money made by a company in training and skilling its, as it was in those cases, agents to conduct marketing campaigns in one, and I think also to conduct marketing campaigns in the second case, Credico and One Money Mail. In both of those cases, those legitimate interests were considered to be capable of protection because they met the sort of restraint that sought to be applied by those companies in those cases. There is nothing wrong with that. First, the court considers what the restraint is.
I think if
And
you're
then
going
the court
to, if
considers
you're going to rely on
the
them,
interest.
we'd better look at them, because neither is an employment case.
No, that's
Indeed,
true.
Quantum is not an employment case. And although Lady Carr has become the Lady Chief Justice and said certain glamour attaches to the case, it is nevertheless a non-employment case in this court which did not say it was making any new law.
Yes.
All right, let's have a look at the two agency cases and see if they help.
Before I do, let me just highlight that the principle in Dorney Day, which is the binding principle that I have already referred the court to, that a covenant may be enforced when the covenantee has a legitimate interest of whatever kind to protect. That was an employment case. It was a case in this court, and it is, I say, binding authority.
It's binding to say there are no category, anybody can come up with any new alleged interest, and it'll so that the restraint of trade doctrine is made narrower and narrower and narrower.
No,
And you may be right.
That's
You
not
may
the
be
principle.
right, but this is the first. The present case is the first employment case of which I'm aware, in which it has been said that there is a legitimate interest in the training of new employees, which is sufficient to enable the employer to recover a high proportion of the employee's salary in the first few months as a debt if the employee leaves. And you say Dorney Day is authority for saying, of course it's a legitimate interest, and that's binding authority.
It doesn't narrow the doctrine at all, my lord, in my submission. I respectfully disagree with that analysis of what it means. What it means is that when a new type of restraint, which the court has not previously considered, falls to be looked at and analysed, then the parties, or I suppose the company, must establish a legitimate interest which reflects that restraint, which is relevant to that restraint, and to artificially enclose the categories of legitimate interest by reference to previous sorts of restraints of trade clauses which have had particular legitimate interests decided in cases. That is what narrows the doctrine. What this is saying is there may be all sorts of new situations in which the restraint of trade doctrine applies, but when the court is looking at such situations, it also concomitantly has to look at what that particular type of restraint is seeking to protect. And it's not limited to the sorts of things that were decided previously. I'm, of course, not going behind the broad principles, the 100-year established principles of proprietary interests. I'm not trying to do that at all. All I'm saying is that this straitjacket is wrong and would be wrong to apply. I think, if I may, my lord, and I know I said I would take you to, I'm not going to take you to Credico and One Money Mail because I simply think I will run out of time to say other things that are more important. You have my point broadly about the law in relation to legitimate interests, and there is a different point to make, which I need to make in relation to legitimate interests, which is separate from my broad point about Dorney Day and the flexibility of the need to look at the legitimate interest as it applies to the actual restraint that is in the contract. And that is to highlight that there has been very little indeed from my learned friend this morning in analysis of the appeal judgment below, the circuit judge's judgment, which is in fact the judgment that is relevant in my submission in considering whether errors of law have been committed in this case. And it is important that the paragraphs of the trial judge's, the paragraphs of the appeal judge's reasons in relation to legitimate interest are properly read and considered, because I say there is no error of law there to bite for this appeal. Honour's judgment is at around page 50.
Yes.
The relevant paragraphs that relate to legitimate interest begin at paragraph 30 and they go through to paragraph 38. The key paragraphs for the purpose of answering the criticisms of made on appeal by my learned friend of the decision on legitimate interest. So rather than the broad principles which I've taken you to in Dorney Day, the actual way in which this judge reached her appeal decision are, I say, paragraphs 32 and 33 of her judgment on pages 51. And she makes a finding, she makes a decision, which in my submission is a common sense point, which is actually rather difficult to paraphrase, because it is straightforward. But she says that retaining employees in which the company has invested time and money training is the same thing as maintaining a stable and skilled workforce, which of course is a recognised type of legitimate interest. So,
but it's also the same thing, or at least it's the other side of the same coin, as imposing a disincentive to leave.
yes,
Okay, good.
Maintaining a stable, trained workforce is a bit shorthand. There's clear authority, e.g. Dorney Day. Maintaining a stable, trained workforce as against their being poached
yes,
is well established.
yes.
But you say it's not a big step to say maintaining a stable, trained workforce against leaving for whatever reason.
Yes. I answered yes so shortly to my Lord's question because if I'm wrong about this not being a restraint of trade at all, and we're talking about a contract, a training investment contract, which is in restraint of trade, but might be justifiable if there is a legitimate interest and if it's reasonable to apply it, that is something which you don't, repeating myself a bit, but you don't have any case law that tells you from past authority how to deal with that situation. There is nothing in Dorney Day or in any of the cases which says that just because maintaining a stable and skilled workforce is an established legitimate interest relating to poaching other employees, that means it can't also be a legitimate interest in relation to one's own workforce. And the evidence which I've now taken you to, those findings of fact which I laboured so much in the trial judge's judgment about the nature of the IT sector and people leaving to take other jobs, And that is a particular factor relevant to this company. This company has a problem. The problem is that it provides training at a cost which it then doesn't get back because the value of the training is so high that the individual can immediately upon completing the training go and get a much better paid job. And repeatedly, before this individual took his contract, repeatedly that was happening. Therefore, there is a problem. The problem is we have an unstable workforce. We train them and they leave. We train them and they leave. We train them and they leave. It is a legitimate interest for us, our proprietary interest in our resources, both in terms of financial resources, time resources, the resources of the company, in any way that you care to describe it, to restrain, in some way, restrain the trained employees from going immediately, they've received their training, so that we can have enough stability in our workforce to get some value out of those trained employees for a time. And the assessment of that, and this is more a question of reasonableness, in relation to which the judge conducted his evaluative assessment at trial. But there are different ways of doing that, different ways of meeting that legitimate interest. One of them is to say, well, as long as you stay for a certain amount of time, then the cost of that training is tapered, all the other points that I made. But the basic point on the legitimate interest question is that this company is entitled to raise its own legitimate interest. All of these cases, all the restraint of trade cases, are not about in principle goodwill, or in principle stable workforce, or in principle confidential information. They are about the reality for that company and for that employee. That's how the cases are decided. And this is no different. The reality for this company was that it could not maintain, or it had an interest in maintaining a stable workforce, which it was not meeting because the value of the training to those individuals was so high that they were leaving immediately upon being trained.
I suppose another way of dealing with it would have been to increase the wages of those who stayed, presumably.
But that was happening too. So that in the contract, there was a ratchet up, guaranteed of increased salary.
Obviously, one could have had a different level of incentive to stay. I mean, it's another way of dealing with it, wasn't it? You say this is the only way to solve the problem. It's not necessarily the only way.
That's a reasonableness question rather than a legitimate interest question. And the difficulty with that, and I know that my learned junior will rise and speak about this, but the difficulty with that assessment of what is reasonable to protect that legitimate interest is an evaluative judgment for a trial judge upon hearing all of the evidence. And it is really very difficult, we say, for an appeal court without the benefit of having heard all the arguments in relation to reasonableness, and without hearing the witnesses, without the cross-examination, without going through the documents which describe, the timesheets where a fire drill is included or isn't included, all of these details that came up at trial, those have all been resolved. A judge has come up with an evaluative assessment on the basis this was a restraint of trade, on the basis there was a legitimate interest. He then assessed that it was reasonable for this clause to be the way that that legitimate interest was protected.
We just stick to legitimate interest. It is what you're saying. The Deputy District Judge's finding, as Mr. Solomon pointed out, was that the claimant company was concerned to protect its investment in training. It's not, as a generality, maintaining a stable trained workforce.
The circuit judge's decision on appeal, and what I say to your lordships is those are the same thing. In common sense terms, what is the difference between maintaining the a stable and skilled workforce and ensuring that the investment that you've made in skilling up your workforce doesn't walk out of the door straight away with no stability. It's the same thing. Well, there's one final point I have to make because it was squarely raised, and I think it's actually very important and important that your lordships give a decision about it. There's a suggestion that this legitimate interest, as presented, is a species of the interest in the employee's own skills and training, such as Saxelby says, cannot amount to a legitimate interest. That's how I understand the appeal is put in part on the legitimate interest, that effectively what the company is seeking to protect is precisely what Saxelby says cannot be protected, which is to say the employee's use of their own skills and knowledge. And the answer to that is that there is a confusion in that argument between purpose and effect, which is extremely important. All non-compete clauses, I'm talking now about traditional ones, just for an illustration, have the effect of restraining an employee's ability to work for a competitor. Of course they do, that's what they say. They say you mustn't go and work for a competitor for 6 months or a year, or whatever it is. So long as that's an effect but not the purpose of the clause, Saxelby says that that is potentially justifiable. In other words, what happened, and this is what happened in Saxelby, Mr. Morris, the owner of the company, got on the stand and he said, well, the real purpose of having this non-compete clause, the real purpose was to stop Mr. Saxelby from leaving and giving his skills to a competitor. So that was both the purpose and the effect of the clause. In reality, if pick any case out of these files where a restraint of trade was upheld, those will be cases where there is a non-compete, where there is an effect on the employee's ability to use his skills and knowledge with a competitor. The point of those cases where the company has succeeded is that they established that that wasn't the purpose of the clause. Yes, it might have been the effect of the clause that happened. Indeed, it must be when it's a restraint of trade that's the effect of the clause. But the question for the court when applying the doctrine of restraint of trade is not whether that's the effect. If it were, no clauses in restraint of trade would ever be upheld. It's about the purpose of the company in seeking to impose that clause. And the final thing I'm going to say is I'm going to ask you to look at Office Angels, which my learned friend took you to. It's at page 726. And it's paragraph 23. It's tab 27, paragraph 23. However, sorry, authorities bundle.
Yes, 7 to paragraph
23. My learned friend has pulled me up a couple of times, not citing all of the words of a case. Well, here is an important example of where my friend missed out absolutely key words in a citation that he presented to you this morning. Paragraph 23. In the case of contracts between master and servant, covenants against competition are never as such upheld by the court. Now, my own friend missed out the words as such when he read that to you, and that is important because the as such is the point. The as such is the point. The restraint of trade doctrine bites, and the clause is not justifiable when what it is doing as such, as its purpose, is to restrain competition or to restrain trade. The fact that there will be effects which are restraining when a clause is applied is none to the point. The question when applying the test of legitimate interest is whether the purpose of the company is to restrain competition, to stop the employee from using their own skills with a competitor. If that isn't the purpose, if the purpose is to maintain their own stable, skilled workforce, or putting it another way, to protect their own investment in the training that they give to their employees, if that is a legitimate interest, then it's no answer to say, but it also causes these other things. Lord, my Leonard Jr. will address you on reasonableness.
Yes.
My lords,
Mr. Welch.
time is short. I have 7 points. They are short points, and I think I can be brief. My lords, my first point is, and it's an overarching thing that deals with reasonableness generally, is that this is, of course, a second appeal. And so it's a review of the lower court. And it's a review of the lower court in the context of this being a challenge to a first instance evaluative decision. And that's important because all of the 6 attacks in, if I can call them that, in the permission skeleton, paragraphs 39 to 45, are really directed only at the trial judge. But my submission is this: an appellate court should be slow to overturn or interfere with decisions that are made on an evaluative basis. I don't want to spend long on the law. I don't have long, but I'd like to just briefly take you to one authority on this, if I may, my lord.
Which one?
It is Authorities Bundle 203, and it is Faye, UK, and Shabani, UK Limited. And it's the part I'd like to refer you to is Lord Justice Lewison.
Sorry, which tab is this, please?
So it's 203.
Is
So tab will be 9.
Is this island hopping?
Yes, quite, my lord, it is. It's island hopping, but Lord Justice Lewison refers to a range of authorities. They're all high authority, House of Lords or Supreme Court authority. He pulls some strands together, having reviewed them, and he makes 6 points. I'm not going to read them.
No.
I won't read them out, my lord, but
You've referred to them. They're very well known.
I rely on them.
Yes. Yes.
But it includes the comment that this is not a dress rehearsal and that you have to assess things like the atmosphere in the court. And those are important factors when you're dealing with an evaluative decision. And lastly, on this point, I just say that there are a number of authorities that deal specifically with restraint of trade, and in particular by reference to the evaluation of reasonableness within the doctrine, and make the same point. The same point comes out strongly in those cases. If I can just refer you to two, I won't labour the point and I won't take you to them, but Credit Co, you've already been referred to it, but paragraph 42, and Harker Sinclair, Lord Briggs, I believe, and it's paragraph 84, Roman numerical 1. I'll move on, my lord. My next point is that paragraph 39 of the permission skeleton that was said by my learned friend for the appellant this morning, that the judge, the trial judge, impermissibly took into account matters arising after the contract, and in particular those matters were the benefits arising out of the rate relationship. Quantum says, again, I'm not going to take you there in the interest of time, but Quantum says that paragraph 60, Roman numerical 5, that you can take into account matters that arise out of the relationship or after the contract was made, but only where you are doing so in order to understand what the parties contemplated at the time of the contract. My Lord, please can I take you to core bundle 115. We're inside the judgment of the trial judge. And at paragraph 46, towards the bottom of the page, in the last 3 lines, I must judge this at the time of entering into the contract. The judge was clearly alive, he knew, he also applied quantum in paragraph 33. He properly directed himself to that paragraph of quantum, into that rule that said that he must judge matters at the time of the contract, but can look at what happened later in order to cross-check or as evidence of what happened when determining what happened at the time of formation. So he's clearly alive to it. And one more, briefly over the page, if I may, my lords. And paragraph 47. And at the top of the paragraph, you almost have to look at what happened to work out what the parties knew. So he's applying that rule that he was clearly aware of because he properly directed himself to it. And he's applying it. So there's no error that he impermissibly took account of matters arising out of the relationship later. He's quite clearly doing a cross-check. He's doing exactly what Lady Justice Carr said in that paragraph 60, Roman numerical 5 of quantum, that she said you can do. And my lords, just finally, if I can take you to the appeal judge, core bundle 55, paragraph 48. She looked at this, and she said that that's what he was doing. She notes that what he's doing is providing a useful cross-check. But my lords, when one considers what the criticism is, taking into account matters that arose after formation and in particular benefits, actually, if I could take you please to supplemental bundle 29. And this is the contract, the training contract. Forgive me, I'm moving swiftly, but I think
that's all right. Supplementary, page 29.
My lord, yes. And it's the contract itself, and it itself contemplated, therefore the parties plainly contemplated, precisely the benefits that the trial judge was looking at, and it said that it was impermissible for him to look at. The contract itself looks at the market value of Mr. Watts's skills increasing, and him, under normal circumstances, being able to get a higher salary. And those are the things that the trial judge was looking at. Well, what happened? Well, they went off and got better jobs. The training was good. It was good because vocational training, you might expect, would be good if it leads to more money and career opportunities. And there are findings that that's what happened. But it's also what the training contract itself contemplated.
It rather suggests that your client's business model is to pay people deliberately less than the market value of their services, in the knowledge that they will certainly want to leave in order to get paid the salary which is greater than what they're going to be paid by you, and that the clawback provision is a way to mitigate that. Is that an unfair way of summarising the position?
My lord, yes.
I thought you might say that.
It is. It's not necessarily the market value of their services, and the market value of their services would be determined by looking at a range of different jobs in that sector, and they, in my submission, they paid a livable wage. It may not be the highest wage, but it was a and yes, my lords, at the time they're contracting, which is what we're interested in, they don't have any skills. They can't do anything for this employer in the IT industry. And all, I'm not going to repeat it, but you've looked at the evidence that Mr. Watts applied for 50 jobs, couldn't find a job.
Yes.
I'll move on, my lord.
All right.
So
that was point 2.
that's point 2. So
Right. Point 3. You said there were 7. So
is that it was not, the contract was not broad and undefined, so that nobody could understand it. It was defined, and it clearly set out what would be offered, what would be received, including its value, likely value, to Mr. Watts later. But both judges were able to construe the contract, assess the contract, make an evaluative judgment on reasonableness, and it was performed. It was, if it was so broad and undefined, it would be difficult to perform such a bargain. But there is a finding of fact that it was performed, and one of the reasons that there is a finding of fact that it was performed was it was raised in the defence that there was a failure of performance. So it was an issue, a different issue, but an
yes.
issue.
Well, don't worry about that. We're not. We assume it was performed, but neither of the judges below seems to have spotted that the training debt is repayable even if the employer dismisses the employee.
Well, it would be repayable at the amount owed upon the
Yes.
date of dismissal and at the staggered rate. But my submission would be, well, if you have had that proportion of training, you have received it, you then should pay for it, but you don't pay. You're not saddled with a big debt. You don't have to pay for all of it. It may even be a fairer deal than you might see in an external provider. If I went and enrolled on such a course, the bar course, and then decided I wanted to leave, I would have to pay all of it, or if I was told I had to leave, I might get none of it back, depending on the circumstances. But certainly, I would be. It was a staggered amount, and it was only relating to the amount that had been relevant to the training received in the relationship. My lord, point 4.
Yes.
Relates to the cost to Geeks being overstated. Now, this is where we find the criticism of the £60 an hour. Now, it was a cost to Geeks to pay salary of mentors, quite plainly, and it was also a cost to Geeks to lose any money that those mentors might be billing for the company when they were diverted from training to training. I mean, my submission would be that this is plainly a cost to a business. If you looked at, say, a law firm, and you had lawyers who were billing clients, and that's what they're meant to do. They're not meant to be training, and they are then diverted from billing to training. They're not billing, and therefore they're not earning money for the business. It's obviously a different model and it's highly regulated. But that is plainly a cost to the business. Properly construed, it would fit into the non-exhaustive list in the contract that refers to measurable loss to the business. Now, just 2 points on this because I'm short for time. But one is the £60 an hour is an estimate. 2, the assertion that that is only attributable to the wages of a mentor, and that is from that you get this 124,000, does not take into account the cost of diverted mentors being diverted to training. Doesn't take into account the fact that the mentors were of a range of seniority, not just the 2 that have been put in the supplemental bundle. This is exactly the type of island hopping that Lord Justice Lewison was warning against, where you look at a little bit of evidence, not all of it, but if you look at Ms. Jessop's witness statement, paragraph 36, supplemental bundle 71, I'm not sure we've got time to go there, but she says that the mentors were, that there were a number of mentors who might be ranging in seniority. Might be a director level of the company, it might be somebody who was marginally just qualified as a QA, and everyone in between. So to take 2 contracts of some very junior mentors and then say, okay, and then exclude from that the cost of attributable to diverting the mentors, and then toss it up and get £124,000, that's not fair, and it is in any event not only wrong in the way it calculates this, but it also is subjecting an agreed estimate that was agreed between the parties, was found to be reasonable by the judge looking at all the evidence, not just snippets of it. It was agreed as an estimate, and it subjects that estimate to an unfair mathematical analysis that an agreed estimate is not designed to be subjected to. And so this 124,000 is nonsense, my lords. And what we're really dealing with, and this is what the appeal judge said, and was right to say, is what we're really dealing with is a sum of £4,560, because that's the cost attributable to mentor training. The rest is attributable to employment cost, and that's where they use the 1.5 times multiplier, which is a common way of determining how much a employee costs a business, and that's a finding by the appeal judge. But so if you take away the employment cost, actually what you're looking at is the training given by mentors accounts for only £4,560. And so actually standing back, the correct question to ask is, was £4,560 a reasonable estimation of the time that it would, or the cost to the business based on the time that mentors were diverted from billable work, which is what they're meant to be doing, to actually training, which is not the primary model of the business. And so was £4,560 a reasonable estimation? And the judge found, and was entitled to find on an evaluative judgment taking into account all of the evidence, that it was reasonable. And my submission is that there's no basis, therefore, to say that the cost to Geeks was overstated.
But what about the 1.5 times salary? I mean, is there a finding? I don't think there is there, that the work done by the employee in the first month was of no value at all, like being at a training.
Well, there are findings that make that plainly the case. I mean, if one was to read it as a statute, then you can't find those words. But that plainly, the judge had said, well, this was someone who couldn't get a job. Couldn't get a job. Why? Because he had no skills or experience that were valuable to an employer such as Geeks. And that's why he was applying 50 times. He couldn't get a job because he was not valuable to such company. And and it's just the other side of that coin that is essentially a finding that he was no value to Geeks in the initial period.
Well, he's working 39.5 hours a week. and he's getting 7.5 hours of training. So what's he doing the rest of the time? Going on fire drills?
I'm sorry, I didn't.
So what's he doing the rest of the time? He must be doing something for the company.
Well, he's training in the first 6 months entirely. Did you say fire drills?
Yes.
Well, yeah. Well,
I mean, what's he doing for the other
fire
32
drills,
hours?
May I say, my lord, he's training in that entire period, but this fire drills point was just, it popped up in a timesheet, and it was accepted by everybody. This is not Geeks' case that fire drills formed part of the training. It's just a misrepresentation of what happened at trial. Actually, what happened was a fire drill popped up in a timesheet, and it was cross-examination.
All right, well, I mean, forget about fire drills, but he's working 39.5 hours a week. He's getting mentoring, I think, of 7.5 hours per week if he works a 5-day week. So he's got to be doing something.
That 37.5 hours is a week.
It's not as much as that. After month 1, or certainly in months 3 to 6, say, it's half an hour a day, isn't it?
Well,
Yes,
It's close
it's less than I said. Yes.
Close to an 8-hour working day, of which half an hour is mentoring in months 3, 4, 5, 6. So my Lord's question was, apart from the half an hour a day of mentoring, what's going on for the rest of the day?
well, these activities are all defined inside the contract. He's learning, he's having questions answered, he's reading things, he's looking at. He's also on-the-job training, so he's absorbing the activities. And if I may say, that's one of the most valuable parts of on-the-job training. Yeah. It's what Mr. Watts could have paid a sum of money to go to a college and learn about IT, but he would not have learned about client interaction. He would not have learned all of the things that everybody knows are plainly valuable in learning from on-the-job training. So this was not just training in IT, but that it was and was found to be. But this was training in IT that was more valuable than an outside course, and it was more valuable because you got to be there. You got to. One knows how valuable it is to obtain a pupillage or a training contract, because it's there that you really learn how to do the job, and that's what Mr. Watts was learning all the time, is how to do the job. But overarching, the calculations given to you don't stack up. They omit the things I've said, and this is an estimate. I mean, an estimate, a reasonable estimate, is a good reason to uphold a provision, not to strike it down. If one looks over the field into the area of penalty clauses, the reasonable estimate is an important part of that. And this is a reasonable estimate found to be by the trial judge on all the evidence.
Right, we better let you get on to your points 5, 6 and 7.
Yes.
Time marches on.
In terms of bargaining power, the trial judge correctly directed himself on bargaining power. At paragraph 43, he referred to Dwyer. He says in paragraph 36, and perhaps we can go there. So it's core bundle 1, 2. And he says that at the bottom of the paragraph, inequality of bargaining power is a significant factor. And as to the weight that he then gives it, so there's no misdirection. There's no error of law as to his direction as to the law. It's there in that paragraph. And the same is said of the appeal judge. But he weighed up the different elements, all of the facts, the evidence that he heard, including Mr. Watts's evidence about his financial circumstances, and treated Mr. Watts's evidence with caution. But it was open to the trial judge and to the appeal judge in my submission to come to the kind of to direct themselves as to significant weigh up all the factors and make an evaluative decision. And I just say that by analogy, the case of Bennett and Day that you might have seen referred to in both of the judgments is a first instance decision by the Employment Tribunal. So a specialist industrial relations tribunal that is well used to weighing up bargaining power between employees and employers. It may be the place where it's done most.
Not sure about that.
Well,
I used to spend a lot of my working life in employment tribunals, and cases about restraint of trade are immensely rare.
I accept that.
But yes, they are employment specialists.
But that is precisely what that tribunal, Employment Judge Ferguson, did. Same exercise, same kind of balancing, and the same result. And it was open to her, and it was open to the trial judge, and it was open to the appeal judge in this case. Finally, or penultimately,
Point 6.
Point 6. So skeleton 45 is that the trial judge failed to give proper consideration to the value of the training to Mr. Watts. So we looked at the cost of the training to Geeks and now the value of the training to Mr. Watts. And I accept that it's clear from Harker Sinclair that where there is an inequality of bargaining power, a particular point that one has to assess is whether the bargain is commensurate to the promise. And here, what's said is that the trial judge failed to give proper consideration to the value of the training to Mr. Watts. And what I say about that, my lords, is that the trial judge found that there was a significant value in this training to Mr. Watts. I mean, it's vocational training, and I ask rhetorically, what more would one want from vocational training than employment opportunities and more money? And there are innumerable findings that that's precisely what he was provided with. I understand, my learned friends will correct me if I'm wrong, but I understand that the criticism is that he went beyond the contractual consideration in determining what the value to Mr. Watts was, and considered the wider benefits to Mr. Watts. And I would like, and it's the last case I'll take you to, but I would like to take you to the authority of Pickwell and Procam CP Limited. It's Authorities Bundle 1108. I'm grateful. Tab 41. Thank you. Yeah. And I would like to refer to paragraph 61 to 63, and this starts at page 1117. And Pickwell is a case, a High Court first instance decision, where Procam invested in trainee agronomists and gave them a route into the profession with greater earning potential. And the Mr. Judge, His Honour Judge Curry, said at 61 that the assessment of value to the trainee agronomists could go beyond contractual consideration. And here he says it includes the conferred benefits upon claimants. In the last 6 to 8 lines in that paragraph, with their acceptance of the formal contract, Procam gave them the opportunity to earn greater remuneration. And he goes on in paragraph 62, in the middle of the paragraph, to say that this included valuable opportunities and first-hand experience observing senior agronomists and interaction with customers. And that's precisely the type of value that was being attributed to Mr. Watts, or that Mr. Watts had received. And those paragraphs in that case, in Pickwell, were cited with approval by Lord Briggs, Hamlin and Burroughs in Harker Sinclair. And if I can finally just take you to that, it's
yes.
paragraph 79.
Tab 44.
Tab 44, Authorities Bundle 1197, tab 44. So it was entirely open to the trial judge to assess wider benefits to Mr. Watts, and he did. And my lords, I'm conscious that my lord is reading, so I will.
Yes. We can just go back to Pickwell. Which paragraphs?
So it's 41, tab 41. It was paragraph 61 and 63.
So in the end, the claimant's lost.
The claimants restrict the covenant in that case was an entirely different one. It was a non-compete.
Yeah.
So not going to lose on that point. But that point of principle in law is the one cited with approval by the Supreme Court.
Oh, the covenants were upheld. The company was counterclaiming.
Yeah. But yeah. Well,
Thank you.
very, very briefly and finally, I'll just say about clause 17. It wasn't a point of contention in the trial. Yes, I'm sorry. Clause 17. I know it was referred to earlier, but clause 17 is the actual non-compete in the contract of employment.
Yes, it was.
And that was not an argument, certainly that I ever remember having in the trial. And my learned friend cited it in his skeleton, and no argument at all, but simply cited it in setting out a recitation of the contract itself. So it wasn't relevant, and the judge below, the appeal judge, found that it wasn't advanced. So it wasn't relevant. I say that. And finally, clause 8.10. It just deals with something. It just deals with a different situation. I don't really understand the point being made about it, but it just simply is a clause that deals with external training and not internal training. That's as simple as that. But it has the same reasonable in my submission repayment mechanism. My lords, I'm sorry that was swifter than
Right.
one might hope, unless
You've been very helpful, Mr. Welch. Yeah. Right. Thank you. Mr. Solomon, I've passed notes around. We don't want to hear you on the question whether the restraint of trade doctrine applies at all. So that leaves the grounds of appeal.
I'm grateful. there are a couple of preliminary points. Milo, can I ask how long I'm allowed to speak for? And I will speak for that amount within a minute, as I did earlier.
Yes. Well, as long as you need to.
Okay.
But it is 20 to 5.
I know. I'm very grateful for that indication. I'll try. If I can have 15 or so minutes. 10. 9. Okay, I'll be quick.
See if you can do it in 10 minutes. But it's an important case. But we have rather overrun.
Yes.
Yeah.
I'm not going to make points about different amounts of time that council took. You asked earlier about the national minimum wage. In the afternoon, this afternoon, my learned junior has typed up and got printed the workings on what the hourly rates were for the contracts in the 2 different years. I wonder if I can just hand those up and give them to you. I've given them to my learned
as long as
they've seen them, but they haven't
Ms. Ferber and
considered them.
Mr. Welsh have seen them.
I can tell you what the answers are, and they're written down in front of you on this document.
Yeah.
I'm grateful for Mr. Platt's Mills. This is a document that my learned friend hasn't seen. So the top figures, the top half of the page, are about the 1920 year, and the bottom half is about the 1819 year, which pertained for 12 days or so, so it's not really relevant. Your lordships can see at the top half, the national minimum wage is £8.21 per hour. The annual salary for Mr. Watts was 18,000. That reflects adopting the Geeks approach as 260 days per year and 8 hours per day as set out in the contract. £8.65 an hour as opposed to £8.21 an hour under the national minimum wage. So it's slightly, but not much above. It's below the UK living and London living wages.
Yes, I think we knew that. All right. Well, don't spend more time on this.
The point.
The exact amounts don't matter. But,
it's there or thereabout. It's just about hovering on the edge of the national minimum wage. But of course, if you recoup money from someone who's left, it would go under the national minimum wage. Now, that's a factor to take into account when assessing reasonableness. Your lordships asked me about the judgment of Lord Justice Leggett in Ingham and ABC as mentioned in Hubble. I've read the case, and the most important section is the bit quoted in, it's not Hubble, it's Dawny Day, I think. And so I won't go further than that. My Lord Justice Males asked about whether the question of legal advice was raised in the court below. It was addressed in the witness statement, supplemental bundle tab 9, page 55, paragraph 26, where Mr. Watts said, the email advised I seek legal advice before accepting the role. I was working full-time in a pub, had no financial means of paying for a lawyer. I was about £1,900 into my 2000 overdraft. I was also under a strict time constraint. Seeking legal advice wasn't an option. And then the next paragraph down deals with discussing the issue with his family. Your lordships will recall that the point about discussing it with the family was picked up by the trial judge, but not this point about legal advice. However, the passage in Quantum where it says legal advice or the absence of legal advice is significant was quoted by the trial judge at Core Bundle tab 8, page 108. So that was plainly a matter directly before the judge. Turning briefly to the cases on... I don't need to address you on restraint of trade. I won't address the cases that my learned friend put forward on restraint of trade. That's what your lordship indicated.
Well, the respondent's notice point, we are not going to uphold the respondent's notice. So
I see.
We're back to your grounds of appeal, legitimate interest and reasonableness.
Right, yes, I understand. I'm grateful. My learned friend, Miss Ferber, King's Counsel, did traverse into reasonableness and made the submission that my client was in debt and it's a very tough job market and this was his only option of getting a job. So in that context, in addition to saying it's not restraint of trade, she said it's more reasonable, it's justifiable. Those are the reasons why an employee in the state my client is in is even more need of the restraint of trade doctrine, and why it is not in the public interest and plainly not reasonable to allow this form of clause to be used. What Miss Ferber has described is an employee in the most vulnerable position in society. And her response is, well, it doesn't matter because it was a take it or leave it position, therefore we can employ you at basically the lowest legitimate amount and then seek to recoup that from you because you had no option. So we say public policy would tell against enforcing such a clause. A couple of points on legitimate business interest and a couple of points on reasonableness, if I may. First, my learned friend said Dawn Day is an employment case. That's wrong. It was a business deal case. The Dawn Day was a bank which had invested in the ex-employee's business. My computer's crashed. Can I have a minute? And it's at tab 31, page 954. You can see on the head note, second and third paragraphs down, the managers and Dawn Day wanted to go into a joint venture. And so, third paragraph down of the head note, Dawn Day invested $650,000 for half the equity and got them to sign up non-competes and non-poaching covenants in that context. It's not an employment case. That isn't determinative of whether or not non-poaching covenants can be potentially legitimate. They can, and Dawn Day is often cited in that context. But my learned friend's wrong to say it was an employment case. Secondly, my learned friend is wrong to say that we are trying to impose some form of straitjacket on legitimate business interests. What I've said to your lordships are what the three continually recognised legitimate business interests are. The case law says, Ms. Ferb is right, those categories aren't closed. And it may be right, it may be, but it's not necessarily right, that there are other categories, like, for example, you may be able to protect your suppliers. Difficult to see actually how that can work. But you see covenants saying, don't poach our suppliers. Fine, that might be at the limit. But what is not within the doctrine, what can never be within the doctrine, is the employer's ability to reclaim amounts it's paid to an employee. And that's what it's trying to do here. And what can never be within the doctrine, I say, is a simple recoupment of an investment. That is not property. And in this case, what the employer is trying to do is recoup an investment in order to prevent the employee using his skills. Not only is that not a legitimate business interest, but it offends against over 100 years of highest authority. my learned friend was right not to take you to Credico and One Money. Those are cases which are not authority for the proposition that you can rely on investment as a legitimate interest. On the contrary, One Money says in terms it was about client relations, and Credico says in terms that the post-termination restraint was unenforceable for that reason. My Lord Justice Males asked a telling question during my learned friend Miss Ferber's submissions, whether are you imposing a disincentive on leaving? And my learned friend said yes. And so that seems to be the purpose of the clause. Not only does that destroy the respondent's notice, but it seems to be the purpose of the clause. Lastly on this, my learned friend said there is a big distinction between the purpose and effect of clauses. I'm not sure that's right in the case law, but she says there's a difference between preventing people leaving and a legitimate business interest of protecting whatever you're protecting, a proprietary interest. Even if that's right as a theory, and it isn't, that's not right on the facts of this case. For example, what my learned friend didn't take you to are the specific findings on purpose that the judge made. So, for example, behind tab 8, core bundle, paragraph 51, page 117, I'm sorry, my lord, forcing me to get the different bundle out. Tab 8, page 117, the true, second line, the true purpose is to prevent people leaving. So if my learned friend wants to rely on purpose, that's what the trial judge found. And again, over the page at 52, page 118, the last sentence, 4 lines down, it's legitimate for the claimant to wish to retain its employees, not wrong in principle to incentivise them by not rising their wages, but making them subject to an obligation to reimburse a training debt. And here's the key point: to prevent them using the skills they learnt at the claimant's cost.
Sorry,
that is...
sorry. Rewind a minute.
Sorry.
51.
Yes.
The concluding point in the defendant's skeleton argument was taking all that into account as an inference that true purpose is to prevent people leaving. Is you say he accepts that?
It's purely a statement of the appellant, now appellant's position.
No, because the judge goes on, he says, the way I've looked at it is this: if I find, as I do, there's a legitimate interest to keep those that the claimant has invested in training, this point doesn't assist. Because if it is a legitimate purpose, i.e. preventing people leaving, the question is simply whether or not the second stage is satisfied. So the judge does seem to accept that and say, therefore, I need to go and assess reasonableness. And over the page, it gets worse, my lord, in terms of purpose. And I've read the last 4 lines of paragraph 52, and the last line in particular is, the purpose is to prevent them using the skills they've learned. Those are the findings of fact against which my learned friend's submissions must be held. My learned friend cannot simply make up a different case for which he wants to make those submissions. Turning to my learned friend Mr. Welsh's submissions on reasonableness, my learned friend started by saying you shouldn't interfere, you should give a lot of respect to a trial judge's judgment. I quite agree, but it is subject to it being obviously wrong. And for the reasons I've set out, which I'm not going to repeat to you, there are a whole series of obvious errors, and they are egregious. The fact that the trial judge plainly took into account the precise amount of the pay that my client was going to receive at his new job, and yet didn't take into account what could be contemplated at the start of the contract, namely that he could be dismissed by the employer after 6 months and owe this debt without any new job, those are material errors. My learned friend seemed to say that all the judge was doing was cross-checking any post-contractual facts against the pre-contractual matrix. That's simply wrong. The judge goes way beyond that. It's not a cross-check. He couldn't have known what the salary would be, for example. And in respect of a question again by my Lord Justice Males, the question your Lordship asked was, is the company's strategy to pay under market value, pay salary under market value? And the answer was no. But the problem with that response is that the very terms of the contract my learned friend relies on says that precisely. So behind tab 4, page 29 of the supplemental bundle, where you find the clawback provisions, it says you understand as a direct benefit of the company's investment, the market value of your skills will increase and under normal circumstances exceed your salary. So they say that.
Well, that's what I was referring to.
Yes. But the answer to your Lordship's question was no. And then that's an unfair categorisation. But that doesn't begin to justify whether it's reasonable. Even if that's right, to recoup salary and what we say are exaggerated expenses. Now, one final point, if I may. My learned friend said at the end, the question of post-termination restraints in clause 8.10 wasn't raised at the hearing below.
No, I didn't. I said 17 wasn't raised. 8.
Yeah, 17 of the post-termination restraints.
8.10 is a different clause.
Yeah.
Well, can I show your Lordship?
Can't remember what 17 is.
17 of the post-termination restraints, my Lord.
Oh, right. Yes.
In supplemental bundle, page 153, which is tab 17, page 153. My learned junior sets out the contract of employment and specifically adverts at F and G to clause 8.10 and clause 17. And both of these clauses were dismissed as irrelevant by the trial judge. And that's obviously an error of law.
I think Mr. Welsh said that the clauses were recited,
Yes.
but there was no argument developed upon them, which seems to be borne out by what you've just shown us, unless there's something else in this.
Well, no, I can't tell you what the argument was. I know that my learned junior bristled during my learned friend Mr. Welsh's submissions and didn't seem immediately to agree with that categorisation.
Well,
but whether or not what was said at trial, with great respect, isn't the end of it, my lord. But when the judge reads the clauses and says a post-termination restraint is irrelevant, notwithstanding that the judge has just set out the bit of quantum which says that if you can enforce a post-termination restraint by other means or lesser means, that's a factor to take into account when you're assessing reasonableness. That's an error of law. So for all those reasons, we say the judgment was plainly wrong. This brutal and draconian restraint cannot possibly be justifiable. And that is the reason, my lords, that is the reason that the respondent has spent so much time on the respondent's notice seeking to avoid this argument at all. Can I have one moment? Yes. Yes, it's one final point, which... I beg your pardon? Yes, this is a point that Mr. Plattsmills reminds me to make, and he can make more effectively than me. But my learner from Mr. Welsh said that the £60 per hour figure reflects more than the salary cost of the mentor and the 1.5 times salary in relation to overheads. But it was said that it reflects foregone opportunity to profit and if that is right, if it's lost profit, then that goes well beyond what a potential legitimate interest could be, and in any event is plainly unreasonable. And that's, I'm grateful to Mr. Platts-Mills for making that point in writing more eloquently than I could on my feet.
Good, thank you.
My lord, I'm sorry, I hesitate to write. Sorry, if you have questions for my own friend, I'll sit down.
Yes, Miss Furman.
May I correct one point? I appreciate that I'm craving your indulgence in order to do it. I'm grateful. You were taken to page 29 in the core bundle, the contract. And my own friend picked up supplemental bundle, thank you, the contract, page 29. In answer to my Lord Justice Miles's question about market value of skills, you were taken to the top of that page, page 29 in the supplementary bundle, where the contract explicitly states you understand that as a direct benefit of the company's investment in your training, the market value of your skills will increase and under normal circumstances exceed your salary for the same reason. That cannot be read in isolation. One also must read the following 3 paragraphs, which include, in the 3rd paragraph, it is the company's policy to increase your salary annually at their discretion as they consider fair and reasonable, based on performance or by at least the national inflation rate. In other words, all that is being recorded in the top clause is that you are on a starting salary which is low because you possess no skills at the point of the starting salary. You will then receive the training and get the skills, and then each year we will review your salary. That is what, in substance, these 4 clauses of the contract say. They do not limit to below market value the employee's salary, the employee's remuneration.
Right, thank you. We're very grateful to you all for your oral, and in the case of Mr. Platts-Mills, written submissions. We will, as I've said at the beginning of the day, reserve judgment. We will send a draft out to council in the usual way. Council know what I'm going to say next. The draft is not sent for re-argument of any points, but only for correction of any obvious errors like dates and our names and typos and so on. And the contents of the draft are confidential to the parties and the lawyers until formal promulgation of the judgment, digital handing down on the National Archive website. I think that covers everything. Thank you all very much for your assistance.
Court rises.